Hi, welcome back to the topic Parent and Children, Part 3. An order for custody may be made subject to certain conditions. This is provided under Section 89 of the LRA. Here, subsection 2 of the section lists down the conditions which may be contained in the order of custody, which are the place where the child is to reside, the manner of education, and the religion in which he or she is to be brought up, the child to be temporarily in the care and control of some person other than the person given custody, the child to visit a parent deprived of custody or any member of the family of a parent who is dead or has been deprived of custody at times and periods as the court may consider reasonable, and the court may also give a parent deprived of custody or any member of the family of a parent who is dead or has been deprived of custody the right of access to the child at times and frequency as the court may consider reasonable, or prohibit the person given custody from taking the child out of Malaysia. Aside from granting an order subject to conditions, the court also has the power to make declaratory order that the parent is unfit to have custody. This is by virtue of Section 90 of the LRA, where subsection 1 states that the court may make an order declaring either parent to be a person unfit to have the custody of the child. Whereas subsection 2 provides that the order can only be rescinded by the court, and on the death of the other person, the unfit parent will not be automatically entitled to the custody of the child unless the court otherwise orders. With regard to child deemed legitimate under Section 75 of LRA, in this situation, its custody shall go to the mother. This is provided by Section 91 of the LRA. It is to be noted here that Section 75 refers to legitimacy of a child due to nullity decree in the case of void or voidable marriage. How long does parents have custody over their child? Section 95 of the LRA states that the order of custody will expire on the attainment by the child of the age of 18 years, or where the child is under physical or mental disability, on the ceasing of such disability. With regard to the changes in custody, Section 96 gives power to the court to vary or rescind any order for the custody of a child on the application of any interested person, with condition that the application for the variation or rescission was based on any misrepresentation or mistake of fact, or where there has been any material change in the circumstances. Not only that, by virtue of Section 97, the court also has power to vary or rescind any agreement relating to the custody or maintenance of a child where it is satisfied that it is reasonable and for the welfare of the child to do so. To illustrate the application of Section 96, let's refer to the case of Puah Meng Lee and Tay Bin Soon. In this case, the wife was granted custody of a 13-year-old child of the marriage. However, the child had refused to return to the wife's house. The husband made an application for a variation of the custody order under Section 96 on the ground that the child's refusal to stay with the wife was a material change in the circumstances. However, Justice Suryadi held that the child's refusal was not such a change as to be considered by the court. On the other hand, in the case of Ree K.O., the couple got married and was blessed with a child. The child stayed with the husband in Penang, while the wife stayed in Kuala Lumpur. Relations between the husband and wife deteriorated, and the wife applied for custody of the child aged 7 years and 3 months. Viva voce evidence was adduced at the trial, and the child was interviewed by the learned judge in chambers. The child was found to have expressed an equal liking to be with both his parents. In granting custody to the mother, Justice Edgar Joseph Jr. held, inter alia, that the welfare of the child should be the paramount consideration, and the child's own views would be relevant to his own welfare. Section 100 talks about the role of welfare officers in custody cases. Here, Section 100 makes it a rule for court to take the advice of person who is trained or experienced in child welfare in determining custody cases. However, the court is not bound to follow such advice. Lastly, Section 101 gives power to the court to issue an injunction restraining the other parent from taking the child out of Malaysia, or may give leave for such child to be taken out of Malaysia with or without conditions. Failure to comply with an order made under this section shall be punishable as a contempt of court. That is all on guardianship and custody. Before we end this discussion, let's watch a video prepared by the third-year law students from Faculty of Law and International Relations, University Sultan Zainal Abidin, on a case of custody. This video and mock trial presentation is adapted from a real case, Lim and Kwan and Julie Tay Swan Sim. So, enjoy the video and thank you for watching.